Hello friends, welcome back to my channel. Today I am going to talk about a very important topic, that is about the constitutional remedies. Now I will talk about the constitutional remedies, that is called the writs. There is a right in India which states that a person can move to the Supreme Court if he or she wants to get their fundamental rights protected. The rights come under Article 32 for the Supreme Court and under Article 226 for the High Court. It is known as constitutional remedy or the writs. A writ means a command of the court to another person or authority by which such person or authority has to act or abstain from acting in a certain way. So that writs are a written order from the Supreme Court or the High Court that commands constitutional remedies for Indian citizens against the violation of their fundamental rights. Article 32 in the Indian Constitution deals with constitutional remedies that an Indian citizen can seek from the Supreme Court of India and the High Court against the violation of his or her fundamental rights. The same article gives the Supreme Court power to issue writs for the enforcement of rights, whereas the High Court has the same power under Article 226 of the Constitution of India. Writs are an important topic often asked in LLB exam students and in IAS preliminary and the main exams. It is very important topic. I am going to tell you about the 5 major types of writs, and each of them has different meaning and different implications. In India, both the Supreme Court and High Court has been empowered with writ jurisdiction. The Supreme Court of India is the defender of the fundamental rights of the citizens. For that, it has original and wide powers. It issues 5 kinds of writs for enforcing the fundamental rights of the citizens. The 5 types of writs are writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and the certiorari. Now, the habeas corpus writs, the literal meaning of the word habeas corpus is to have the body of. This writ is issued to enforce the fundamental right of individuals' liberty against unlawful detention. The facts about the habeas corpus writ are that the Supreme Court or the High Court can issue the writs against both private and public authorities. Secondly, the writ of habeas corpus cannot be issued when the detention is lawful and when the proceeding is for the contempt of a legislature or a court. When the detention is by a competent court and the detention is outside the jurisdiction of the court. Secondly, the writ of mandamus is that the literal meaning of the writ of mandamus is this writ is used by the court to order the public official who has failed to perform his duty or refused to do his duty to resume his work. Besides public officials, mandamus can be issued against any public body, a corporation, an inferior court, a tribunal or government for the same purpose. There are many facts about the writ of mandamus, and that is, unlike habeas corpus, mandamus cannot be issued to enforce departmental instructions that doesn't possess statutory force and to order someone to work when the kind of work is discretionary and not mandatory, to enforce a contractual obligation. Writ of mandamus cannot be issued against the President of India or the state governors, or it cannot be issued against the Chief Justice of a High Court acting in a judicial capacity. Now, the writ of prohibition. The literal meaning of the writ of prohibition is to forbid. A court that is higher to position in issues a prohibition writ against the court that is lower in position to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. It directs inactivity. Writ of prohibition can only be issued against judicial and quasi-judicial authorities. It cannot be issued against administrative authorities too, legislative bodies and private individuals or bodies. And now the writ of quo warranto. The literal meaning of the quo warranto is by what authority or warrant. Supreme Court or High Court issues this writ to prevent illegal usurpation of a public office by a person. Through this writ, the court inquires into the legality of a claim of a person to a public office. Some facts of quo warranto in India are: quo warranto can be issued only when the substantive public office of a permanent character created by a statute or by the constitution is involved. It cannot be issued against private or ministerial office. This writ gives the right to seek redressal to any individual other than the aggrieved person. Now the writ of certiorari. What is writ of certiorari? The literal meaning of the writ of certiorari is to be certified or to be informed. This writ is issued by a court higher in authority to a lower court or tribunal, ordering them either to transfer a case pending with them itself or quash their order in a case. It is issued on the grounds of an excess of jurisdiction or lack of jurisdiction or error of the law. It not only prevents but also cures for the mistakes in the judiciary. Some facts of the writ of certiorari in India are: before 1991, the writ of certiorari used to be issued only against judicial and quasi-judicial authorities and not against administrative authorities. After 1991, the Supreme Court ruled that the writ of certiorari can be issued even against administrative authorities and affecting the rights of individuals. It cannot be issued against legislative bodies and private individual or bodies. Now I am going to tell you about some general facts about writs in India. Number 1, Article 32 of the Indian Constitution empowers Parliament to authorize any other court to issue these writs. Before 1950, only the High Court of Calcutta, Bombay and Madras had the power to issue writs. Article 226 empowers all the High Courts of India to issue the writs. Writs of India are borrowed from the English law, where they are known as prerogative writs. Dear friends, if you like today's legal topic, please don't forget to like, comment or subscribe my channel. I will be back very soon with a new legal topic. Till then, bye bye.